but I will give the floor to Dean Michel Cannarsa from the Catholic University of Lyon, who, if my information is correct, supervises a Future of Digital Technologies legal clinic, and he also teaches and researches legal translation. So I'm hoping that today he's going to very clearly translate to us some of the speculative problems and challenges he thinks that our digital Europe is facing. And the title of his presentation is going to be Artificial Intelligence, but Real Concerns. Professor, the floor is yours.
Thank you. Thank you very much, Professor Suliak. And by the way, the title is not original at all. So sorry for that. Well, just a few words to express my warm gratitude to the Institute of Comparative Law, to the Hungarian National Assembly, and the Ministry of Justice for the very kind invitation. As you all know, in recent years, artificial intelligence is having increasing repercussions in the field of law. And the epochal industrial transformation and paradigmatic shifts it generates in many sectors have, from a legal perspective, a structural impact on legal rules and on legal practice. Moreover, and it has been mentioned by previous speakers, the speed of these transformations also impacts on the regulatory response that the legislator is able to provide. Although legal experts, contrary to ethicists, have traditionally shown little interest in artificial intelligence, algorithms, machine learning, and so forth, it is now impossible for them to ignore the impacts of artificial intelligence on the law. Many recently issued ethical guidelines, principles, or recommendations come into play. A multitude of these non-binding texts have been released in the past few months and years by many governments, governmental and non-governmental organizations. However, the answer to the phenomenon is still at a rather early stage. One reason for that being that much of what could be the impacts of the widespread use of artificial intelligence in our societies is uncertain. All the current ethical guidelines and regulations proposals dedicated to artificial intelligence mention the risks and opportunities brought by it. Regarding the opportunities, it is not surprising that they reside mostly in gains of productivity. Regarding the risks, most of the current ethical guidelines for the development of AI focus on fundamental rights. These rights, as far as the impact of AI is concerned, materialize into human dignity, freedom of the individual, equality, non-discrimination, and solidarity and citizens' rights. According to me, it would be naive to think that AI could bring gains of productivity and spread harmoniously without hurting fundamental rights. Regulators do not have previous preconceptions about AI developments and do not have previous legal rules specifically designed to deal with them. There is therefore a very challenging, almost unrealistic opportunity to draft rules on an international scale. This approach would, of course, create a reliable economic environment for the development of AI. It would also, and more importantly, drawing analogies with the human rights area, be based on a universal approach. The said universal approach seems to be particularly needed considering the interests involved, that is to say, fundamental rights and freedoms, but also the frequent immaterial nature of AI applications and usages, making it hard to lock them behind national borders. Prior to any regulation, and by analogy with the field of bioethics, an area, as you know, in which technology has to deal with philosophical, religious, moral, and political concerns, regulators generally rely not only on scientific, economic, and legal studies and analysis, but also on public debates with the broad participation of stakeholders. This is part of a political process requiring governments to keep their finger on the civil society's pulse on such sensitive issues. The same seems to be the ongoing process with AI. However, the analogy with bioethics highlights one major concern about ethical guidelines for the development of AI. Binding legal rules generally precede new technological implementations in biology and medicine, whereas AI is already spreading fast in many different aspects of life without clear and efficient regulatory boundaries. I think that clear legal rules, that is to say hard law, adapted to new realities are strongly needed in order to make sure that unlawful consequences of AI developments are not left without a legal response. This requires to renounce to a speculative approach and to focus on practical examples into which AI is already deployed and where it generates legal problems to be solved. At the very least, a fitness check of the legal rules in all the potential impacted areas of law, contracts, torts, law of persons, criminal law, human rights, and so on, should be conducted in a systematic way for any use case of AI. This requires, of course, a titanic effort and a full commitment of the legal community. This would be the only way to determine whether new legal rules for AI and digital technologies are needed, and or if existing legal rules can adapt through interpretation to new situations. As you mentioned, we in our Future of Digital Technologies Law Clinics, we invited or thought about practical cases, near future cases in which those questions could be raised. So we started, of course, with autonomous cars, but we expanded our reflections to the use of artificial intelligence in care homes for old people, or in the most recent cases, we thought about an autonomous shuttle that, on the basis of the algorithm on which the functioning was based, was progressively going only in beautiful parts of the city and avoiding the other parts where the machine assumed that the roads were in bad shape and where the people would be more likely to create damages to the shuttle, for example, which brings, of course, concerns of discriminations. So, and you have the impression that these kind of examples could be multiplied in any areas of our societies. The more you implement artificial intelligence tools and programs. As you probably know, the European Union strategy in the digital field relies on various principles like awareness raising about AI, institutionalized dialogue between policymakers, developers, and users of AI technology, an appropriate governance framework, and a review of the adequacy of the current regulatory regime. Regarding the review process, the Artificial Intelligence High-Level Expert Group of the European Commission suggests to base it on the risk-based approach, to use sandboxes to set legal and ethical standards and to take into account both individual and societal risks. So the recent proposal of the Artificial Intelligence Act, as you probably know as well, implements the said strategy and the said approach, and more precisely the risk-based approach. So at this stage, the European Commission suggests to limit the introduction of new mandatory rules to to be imposed on the relevant actors to high-risk AI applications only. Among the many items included in the suggested review of the adequacy of the current regulatory regime process are product safety, civil liability rules, criminal liability, data protection rules, non-discrimination provisions, cybersecurity and competition rules. The European Commission is keen to ensure that any regulatory intervention is focused and proportionate, which in other words mean regulatory parsimony. A risks advantages approach is likely to be put forward and is put forward actually. These attempts are just the first steps of a colossal agenda with many difficulties lying ahead. Little evidence is available to inform policy making. Technology is developing rapidly, more than regulators' capacity to understand it properly and to react, requiring a kind of continuous systematic stress test for regulations and governance structures and institutions, enforcement agencies, and so on. So far, the various reflections on what the developments of AI should be have been made at a rather abstract and quite speculative level. As traced by, for example, the Berkman Client Center's at Harvard Law School study, there's a wide and thorny gap between the articulation of these high-level concepts and their actual achievement in the real world. There is certainly a legal vacuum at the moment, and it will take time to fill it in. It is, at least this is my opinion, difficult to admit that AI developers should be in charge of conducting an assessment and questions as, did you take measures that ensure that the AI system does not negatively impact democracy, or does the AI system respect the freedom of expression and information and or freedom of assembly and association? These are the kind of questions that the developers should ask and implement, by the way, in the development of their technologies. If we go that route, the trade-offs between fundamental rights and economic stakes will always be resolved in a negative way for individuals' rights. The question is not if a given AI product or service is good or bad. What matters is how to determine whether someone, a human, the natural person, is liable and or guilty, and on which grounds, in case of damage, of course. There is a need to find a way to operationalize legal compliance of artificial intelligence after the past period of a standby and wait and see posture. As previously mentioned, the speed of the technological innovations currently unfolding is a feature that needs to be taken into account. This factor seems to favor a legal approach and legal rules that are flexible enough to prevent a risk of rapid obsolescence. Moreover, this approach would be rather adapted to the absence of uniformity among technologies. A concept of ethical by design could be translated into technical requirements. In their journey into the AI world, legal experts, so practicing lawyers, judges, notaries, and academics, have to acquire new skills and take relatively new approaches. The new skills in question are largely technical ones. Lawyers have to dip more into the world of computers, automation, algorithm, machine learning, and AI, which requires a significant investment in time and efforts. This trend, I think, is underway and is the only way to study the current industrial revolution and bind it where legal principles impose to do so. If the legal community doesn't do so, one of the risks is that technology will shape legal rules and legal practice, which of course is a source of concern, or should be a source of concerns for all of us. Thank you very much. I hope it was not too long, and should there be questions in the end, I'm happy to take them. Thank you.